Thank you so much for still coming out during the school holidays. We know how mad this time of year can be with the schools obviously being off and now trying to rearrange diaries and do what we can with kids around at home. So it's fantastic you've chosen to join us this morning. This is the last of the Performance and Capability Masterclass series. We are announcing a new Masterclass series, which I'm going to mention at the end of the session. But this session, we are talking about sickness and the skill deficit. So managing the difference when we've got a capability situation where we could have someone who is struggling with capability because of sickness, which could be attendance as well as their sickness in the workplace, but then also where we've got a skills deficit. So technically under the same process, but two very, very different things. And we will be looking in this session at how we manage those differences. So who are we? Who am I? For those of you who haven't met me before, I love seeing so many familiar names. So I'm going to keep the intro to an absolute minimum. My name's Alyssa. I am a specialist employment solicitor. Worked in private practice for a very long time before setting up Heroes and developing our product offering. So in addition to consultancy and legal advice, we also have some fantastic HR software that we built. E-learning, we now have Harry, our AI agent, and it's all now wrapped up in insurance as well. So if something goes wrong, the insurance covers you for legal fees, settlements, and compensation if you end up in tribunal for just one subscription a month. So if that's of interest to you, don't hesitate to book a call. But without further ado, we are going to dive straight into this session because, as always, I'm going to run out of time because you know that I can't manage my time on these sessions if you've been on them before. So let's talk about the capability process. So as I said, as I introduced the session, we're talking about sickness versus skills. So on paper, this could look identical. We've got two employees that are perhaps missing the same target. So the paperwork sees no difference. Our spreadsheet shows we might have two people who are underperforming. However, the law does see a difference between them. So where we have a skills gap and a health issue, these are two completely separate problems. We're going to manage them in two separate ways and really with two separate processes, despite it falling under that big capability umbrella. So the real risk here isn't that we're too soft or we're too tough, it's that we run the wrong procedure because you never really asked with these individuals what was really going on. And I would say the bigger mistake that some people make, particularly when it comes around attendance, is that they're managing this as a disciplinary process. So we talked about this on one of the previous masterclass sessions around making sure that we're choosing the right reason for dismissal. So in that termination masterclass series, we talked about dismissal process, we talked about capability process, and making sure we pick the right lane because it's a real key thing that tribunals pick up on, and it's a really easy way to land yourself with an unfair dismissal. And then when we talked about managing short-term absences and those informal conversations, we touched on this then. So if you need to have a bit of a refresh of those sessions, they are available on demand. If you can't find them, reach out to the team and we can make sure that we get those over to you. So we have one word and two very different problems. So capability, as I've said, is this umbrella that covers these two situations where we've got that skills gap and then where we've got sickness absence issues. So capability is one of the potentially 5 fair reasons to dismiss. So again, as I've said, we touched on this in our dismissal masterclass series, but it does cover these two very completely different situations. So skills deficit is where we've got someone who can't do the job to the required standard. So we have an ability issue. So it could be that they need training. It could be they don't have enough experience in this area. They might need a supervisor or a mentor, or perhaps they're just not progressing in terms of those skills that we need in line with how a role is progressing or how industry is changing or how that role is developed in accordance with how the business has grown. Ill health, we've then got someone who can't do the job or is struggling to do the job because of a health condition. So it's not that they won't do the job. It's not necessarily that they can't because of skills. It's because their health is preventing them from performing or attending at work. Now, it could be that we get a bit of a mesh of the two, where actually someone does have the requisite skills, but their health is meaning that they're not able to perform them to the standard that would typically be expected. So whilst we do separate the two off, there could be situations where we do have this nice clean difference between the two. We always need to remember we are dealing with people. Situations are very dynamic. Nothing is ever straightforward when we're talking about capability, and just to anticipate that there could actually be the two of those in play. And then, as I've said, we've got conduct. So this is where somebody won't do something. So they have their job description. They know what's expected of them. They've been trained to do it. We know they've got the skills to do it, but they are refusing to do what is asked of them. It's a failure to follow a reasonable management instruction. That's a disciplinary matter. It's not capability at all. And that's not really something that we're touching on in this session. But it is really important that we differentiate between the can't because of skills or health and the won't, which is more conduct based. So why do we need to get this right? Well, the clock is ticking because on the 1st of January 2027, the qualifying period for unfair dismissal comes down from 2 years to 6 months. By then, the time limit to bring a case to tribunal will have been extended to 6 months from 3. So we're going to be waiting even longer, and we've got that risk hanging over us for even longer. So anyone who was in your workforce by the 1st of July 2026, so 1st of July this year, they are going to have the right to be able to bring an unfair dismissal claim on the 1st of January 2027. What this means is we don't have 2 years for people to be able to settle in, find their feet, us to faff around, forget about the probation, forget about the appraisals, not be doing those informal catch-ups and check-ins that we've talked about in the earlier capability sessions, not to be having those touch points where we are talking about clear goals and setting expectations. So all that good stuff we've already talked about. We don't have that latitude once we get into next year. 6 months goes incredibly quickly. We're already more than 6 months through the year. Christmas is closer to us than January of this year. It goes so fast. So do not underestimate how much of a change this is going to be in terms of culture. We need to be onboarding people, setting our goals and expectations, making somebody has the skills, the training, the management, the supervision so that they can absolutely bring their best self to work, making sure we're having those informal conversations, those regular appraisals and formal catch-ups, that we're documenting everything. If we've got somebody struggling, look at the performance support that we can put into place, making sure if it's not going well, we're issuing those warnings, doing what we can to try and fill that skills gap for them so that when we get to that final meeting before that 6-month point, they're not surprised they're at the point where they're losing their job. That's a lot of work in 6 months. It's a lot of meetings. It's a lot of diary management. It's a lot of touch points. So we need to be really, really clear on what processes we need to be putting in place, which parts of the law apply, because we're not really going to have that time and that latitude to be able to be lackadaisical about this. So we've got a poll on screen. So when an employee's performance suddenly drops, what is your first instinct? So number 1, start a performance improvement plan. Number 2, have an informal conversation first. Number 3, explore whether a health issue could be involved. And number 4, it depends on the circumstances. So 15 of you, 100% of you saying had an informal conversation first. That'll be my preference. So for those of you who did come on the session where we talked about informal chats, hopefully that's why you've ticked that one. And then it depends on the circumstances. Yes, it can depend. However, what I would be saying is if we've identified a performance issue, if something has suddenly dropped and it seems a little bit out of character and we don't really know what's going on, informal conversation. What's going on? You don't seem yourself at the moment. We seem to have noticed a bit of a performance dip and this isn't really kind of within what we'd expect from you. Do you want to have a chat about what's going on? So it's not performance dropped, right, that's it, we're on a formal PIP or we're into warnings. We're checking in with this employee to see, well, what could be going on. Maybe something isn't right at home, maybe their health isn't quite as good as it used to be, or maybe the nature of the work they're doing has changed and there is that sudden skills gap and something's dropped. But these early informal conversations are where we are going to be really, really equipping ourselves with lots of useful information that's going to inform not only which process or procedure we go through, but actually the direction, the tone, and how we approach a situation with an employee. So let's go through step by step then. Step one, we establish is it can't, won't, or if someone is unwell. So if they won't do it, it's conduct, that's a disciplinary matter. If they can't do it, performance capability, skill deficit process. So we're thinking, what is it? What's the gap? Why can't this person undertake the role to the standard that we're expecting of them? If it's unwell, then it's ill health capability. So we're going down medical investigation, considering reasonable adjustments. We're consulting with the employee and seeing what can be put in place to support them. So for the can't do it and the unwell, these are two supportive processes still at this point. It's what can we do to help fill that skills gap, or what can we do to either adjust or support you so that you can meet the expectations of your role. So these categories can blur, as I've already said. The same person could sit in more than one box. So we never assume, and certainly where we've got somebody who, for example, has a skills deficit, but there's also a bit of health perhaps going on, we're not thinking, oh, I was on that session with Alyssa, there's 3 boxes, I've got to pick one. This isn't like where we're picking one of the 5 fair reasons for dismissal, where we do really need a lane by the time we get to the end of it. This is not a case of once you're in one box, we force an employee down that supportive route, whether they like it or whether it's helpful or not. We just need to be mindful of everything else that's going on so we can factor it into what we're offering, the supportive stuff that we're perhaps going to be looking into, and thinking about what it is that this employee might need. So let's have a look at the 3 routes in a bit more detail and see what we mean by them. So disciplinary, I'm not going to go into this in too much detail because we've done a whole masterclass on it. So if we've got someone who won't do it, it's disciplinary process. We're going to investigate the behavior. We're going to invite them to a disciplinary hearing, which we're going to do in a compliant way. So we're going to have a compliant letter. We're going to give them the right to be accompanied, make sure it's held within a reasonable time limit, and we give them all the evidence of what it is that we say that they've done and warn them about the potential consequences. If we find the conduct has occurred, then we've got warnings, potentially up to dismissal if warranted, and then we also give the right of appeal. So that's disciplinary. If we've got a skills gap, so it's someone who can't do something, then we're going to look at support and improvement plans. So we're going to set clear and measurable standards. So last session where we talked about goal setting, session before that where we talked about appraisals, session before that where we talked about informal conversations. All this sort of stuff now comes into play. So setting clear, measurable standards, informal support, and looking at what training we can offer. If we need to go on to a formal improvement plan, make sure that we are absolutely following those key steps that we talked about in the goal setting section, where we're talking about SMART goals. So we're specific, we're measurable, it's achievable, it's realistic, it's time bound, that we're doing regular reviews, we're checking in regularly. We're not just leaving something months and months and months and then telling somebody that they've failed a process. That we are, where there are any formal sanctions being considered, that we are giving the right to be accompanied as a matter of best practice. Where we are then reaching formal points, that we're issuing warnings, and if there's no improvement, as a last resort, we then look at dismissal, remembering, of course, that because this is capability, it's dismissal with notice, and that we are giving the right of appeal. If we've got someone who can't do it because they're unwell, then it's medical investigation and a consultation process. So we're going to be obtaining up-to-date medical evidence. So getting a report from the GP, looking at an occupational health referral. When we're doing occupational health referrals, this is just a quick sort of pin at this point. Sending someone off to occupational health and saying, what's wrong with this employee and what do they need? It's a bit of a waste of money, frankly. And I see this all the time. Occupational health is going to be generic and useless if the information that we give them is generic and useless. What occupational health needs to understand is what role is this person doing? What are the issues that we've identified in terms of where we think somebody is struggling? Are we briefing them with perhaps those GP records or anything that we have on file, obviously with the permission of the employee because we're sharing medical information? And then a specific list of questions that we want occupational health to answer. Can this employee do this role now? Will this employee be able to do this role in the future? What is the likely time period that we think the employee might need to be able to do this role? If you think the employee can't do the role, what adjustments could be put in place that would support the employee to do that role? How long will that then take for improvement? I have issued instructions to occupational health where questions have gone on for several pages because there's lots of stuff that we need to know. So there's no point sending them off to a paid appointment. We get a very generic report back where they tell you what the employee is suffering with and a list of adjustments that might help, but they're not tailored to that specific role because we haven't given the information to occupational health. We then get the employee into a capability meeting. We ask them all the questions that we wanted to ask, and the employee goes, I don't know. I'm not a doctor. Occupational health could have answered this. If you then want to send follow-up for occupational health, they're either going to want another meeting with the employee that they're going to charge you for, or they're going to refuse to answer those questions. So it's really, really important that this just isn't a tick box part of a process. We really need to engage brain at the point where we are referring to occupational health and think, why are we doing this? What is it that we want to know? We're not just asking for a list of generic reasonable adjustments. Remember, we touched on this in the last session. I'm going to touch on it a bit later in this one as well. Occupational health are not going to be able to help us when it comes to suggestions around support, reasonable adjustments, and what someone can do and timescales if we don't tell them what the employee is doing day to day, where we're seeing the gaps, what support we've already put in place. That's another pet hate, is where we don't tell them what we've already put in place, and then they just suggest that again. It's a waste of money. So really, really making sure that we are specific with these instructions. Making sure we consult the employee, their view matters, consider reasonable adjustments. My preference is always kind of assume that everybody is operating with a disability, because then if it's a matter of course, we're looking at reasonable adjustments and support, we're not going to get caught out later on. Assess how long the role can be held either open, or how long this situation can be sustained for before it becomes something that's critical and we need to be looking at moving somebody on. Are there any other alternative roles? Look at every available other alternative option before dismissal. And then we're also giving the right of appeal. Got a quick relevant question there. So can an employee request to see the referral of occupational health? Are we obliged to share this? So if we are making a referral to occupational health, giving information and asking questions, that is technically personal data of the employee. They do have the right to see it. And what I would say is, if we're nervous about an employee seeing what we're asking, the question we need to ask is, why are we nervous? If it's that it looks like we're trying to move somebody over to dismissal, well, hopefully we're in the later stages if we're asking those sorts of questions at occupational health, where we're looking around those terminal options. But ultimately, this is information that if we went to tribunal, if an employee did a DSARS or subject access request, they're going to get their hands on this anyway. So if we have that nervousness, the question is, why am I nervous about this? What are the questions? What's the information I don't want them to see, and why? If it's that we feel they're going to hold the process up, they're going to object to the questioning, if they're going to object to evidence going across, we can kind of deal with that. If it's our process that we're saying, look, we want to refer to occupational health, they see the letter and they go, I'm no longer consenting. Well, then they've put a barrier in terms of that medical investigation, and we're going to deal with that process with the information that we have available. And the reality is, if we don't get that further medical evidence, the chances are it's actually probably going to speed things up in a way that the employee's not going to be that happy with. So the answer to your question is yes, we should share it. If we have a nervousness around it, let's analyze why. If it's that we feel like the questions are a bit awkward, the employee's not going to like them, the employee doesn't really like a huge amount of what's going on here, to be honest. So think about maybe how we're phrasing it, what information we're trying to secure. If it's that we think the employee is going to object, well, actually, that can sometimes give us a bit of a shortcut. Not that we should be trying to take shortcuts in any of this, but if it's that we've got an employee who goes, no, you're not contacting occupational health. No, I'm not giving you any GP records. No, I'm not giving you any information about my medical history or what I can and what I can't do. And they've been off sick for like 6 months, 9 months, a year, 18 months. And we go, well, we don't know anything of this background. We don't know what you can do. We don't know any timescales for your return. You're not helping us in terms of medical investigation. The reality is we're probably going to be looking at a final capability meeting in that instance. So that's the 3 different routes. Route A, managing a skills deficit. We're going to set clear, measurable standards. So back to session before this one when we talk about goal setting. So making sure they know what good looks like. This step is skipped more often than you would think. So make sure they know what that standard is. Start informally. So honest conversation, training, support, and genuine time to improve. 3, formal improvement plan if needed. So realistic timescales, genuine support. It's not just a paper exercise to build dismissal, because tribunals are really good at spotting where we're kind of pushing things so they're just out of reach, so someone's inevitably going to fail so that we can get to that final meeting. Then fair formal stages, so regular reviews, making sure we give the right to be accompanied, issuing warnings, we're not just going straight to dismissal, and making sure that whenever we issue a sanction that we give a right of appeal at every formal stage. So that's managing the skills deficit. Managing genuine sickness. So this is route B. We get up-to-date medical evidence, so GP letter, and where warranted, occupational health referral. We're not doctors. We're not going to be second guessing or asking ChatGPT what somebody can and can't do. We can use it to educate ourselves a little bit about a condition if it's not something that we've heard about before, or perhaps it's one where we feel that we've got some preset ideas about how it affects an individual, because everything affects everybody in a slightly different way. So it might be that we do a little bit of research just so that we understand a little bit more about what we're dealing with. But where it comes to anything conclusive, anything diagnostic, anything about what this employee can and can't do, we need to be reverting to their medical team. Consult the employee, ask them about their health, how they're feeling, what they can do day to day, what they feel they can do in their role, what they feel they can't do in their role, what they can do at home. Now, that may seem like an intrusive question, but actually understanding what their abilities are outside of the workplace may give you a bit of creative thinking in terms of how we can adjust things at work and perhaps other things that we can give them to do if we are trying to fill a role. Their perspective also matters, and a tribunal will want to know what it is that you asked an employee and how you consulted and engaged with them. Consider the business reality. So how long can this role realistically be held open, and what is the impact on the team? Again, really generic statements where we go, oh, this has gone on for too long, the business can't sustain this, with no option other than to look at dismissal. When a tribunal then comes to look at this and says, okay, why wasn't this sustainable anymore? And you go, oh, well, they've been off for a long time. Why is that not sustainable? So we need to be really, really clear on what the actual impact of the business has been, is being, and is expected to be. Short term versus long term. So persistent short term we can trigger those warnings. It can eventually trigger us to get to dismissal, but we still want to investigate cause. And for long term, we want evidence, adjustments, and alternatives first and always before we get to dismissal. So the trap when a skills problem is actually really a health problem. So underperformance is often a symptom. So where you've got someone who's suffering with stress, anxiety, depression, the menopause, they've got neurodiversity challenges, these can show up first as missed targets and slipping output long before there's any formal disclosure that anything's going on. Some employers will think, well, if I don't ask the question about what's wrong, I'm not on notice of disability, therefore I'm home and dry on a disability discrimination case. That's not how it works. If there's a point where you should have had reasonable knowledge of someone's health conditions that then later transpire a disability, you're going to be triggering those responsibilities, which is why I always say, as a matter of best practice, consider reasonable adjustments and treating everybody as though they have that protection, even if you don't verbalize it that way, because it's just going to give you that extra layer of protection if things don't go your way later on. So never ever run a performance process without first asking, is there something underlying this? And it can very, very quickly, there can be a manageable health issue that can very quickly turn into a disability discrimination complaint. So understanding what's going on behind someone's poor performance is essential to make sure that we're taking them down the right route and applying the right support. So signals a sudden or unexpected drop from someone who was previously performing fine. The right move is pause, ask what's going on, consider occupational health referral before you escalate, good, kind management and good legal protection. So making sure that you're liaising with your advice team, because sickness issues and disability discrimination can be so expensive if we get this wrong. Excuse me. So disability, what's the risk? Why do I keep bringing this up? It's the risk that's got no qualifying period and uncapped compensation. So day one right, and actually it's a pre-day one right, we can trigger this during recruitment. So these claims exist from the very first day of employment, not 6 months, not 2 years, and there's no cap on compensation. Injury to feeling awards come in bands. So we talk about the Vento bands, but for the most serious types of discrimination, the tribunal has the discretion to award something that is uncapped. It's broader than you think. So under the Equality Act, disability is defined very widely. So it's any physical or mental condition that has a impact on someone's ability to undertake day-to-day activities, which does include work and is likely to last 12 months or more. Tribunals have found that depression meets that. Most neurodiversity conditions meet that. Certain types of anxiety can, so if someone has an anxiety disorder. So making sure that we're not brushing something off and considering it to be minor when it could potentially trigger that definition. Positive duty to adjust. So employers must make reasonable adjustments. The duty is on employers to come up with the reasonable adjustments. It's not on the employee to come up with these for you, as we discussed on the last session. I'm going to do a quick run through of that discrimination stuff just because it's so important. So as I've said, under the Equality Act, it's where we've got a physical or mental impairment where it has a substantial and adverse effect on someone's ability to undertake day-to-day activities, including work. So that's got to be more than minor or trivial. It's got to be long-term, so must have lasted or be likely to last for at least 12 months. And as we said, it impacts their ability to undertake normal day-to-day activities. If this is a useful slide for you, the deck will be available afterwards and for these next couple of sections as well. So when we talk about reasonable adjustments, the trigger for reasonable adjustments is under Section 20 of the Equality Act. So the duty to make reasonable adjustments doesn't just arise because someone has a disability. It's triggered where someone has a substantial disadvantage compared to non-disabled people, either by provision criterion or practice in the workplace. So for example, if you have a capability process that is a policy that you put in place for people who are off sick, technically that treats everybody the same, but somebody with a disability is more likely to suffer the negative effects of that policy. That is a PCP, that's a provision criterion or practice. It puts that disabled person to a detriment or makes them experience a negative effect. And that then potentially triggers the need for reasonable adjustments. So we look at maybe extending trigger points under that policy, delaying before perhaps the formal stages are applied, that sort of thing. Or where we have a physical feature that places somebody at a disadvantage compared to non-disabled employees, then that also triggers the need for reasonable adjustments. Or where somebody requires an auxiliary aid. So we have to be proactive. It's an employer duty. So sitting an employee down and saying, right, what reasonable adjustments do you need isn't enough. We need to be proactive, which is why that medical investigation is so important. Adjustments can relate to policies, physical features, and the provision of auxiliary aids, but it needs to be something that's going to actually mitigate or reduce or alleviate entirely that disadvantage. So just throwing a list of supportive measures at somebody isn't enough. It needs to be targeted at where they're actually experiencing the disadvantage. And then we have the reasonable test. So what is reasonable depends on factors like the effectiveness of the adjustment, its practicability, cost, and impact on the business. Just writing something off as unreasonable without going through some sort of exercise to prove why that's the case is unlikely to impress a tribunal. You need to, at the very least, have looked at what could be put in place. And then if we think something isn't reasonable, be very, very clear on why we think that is the case. So reasonable adjustments in practice, you're not expected to do the impossible, but you are expected to consider adjustments properly and record what you've done. So a tribunal will ask what was considered, not just what was done. Adjusting the performance process itself can be classed as a reasonable adjustment. So allowing more time on improvement plans, modifying targets, perhaps starting them low and scaling them back up over a reasonable period where a health condition is affecting performance. Things like phased returns, flexible hours, so adjusting duties, reducing hours, flexible to altered start times, adjusting targets and deadlines, providing additional equipment, software, and modified performance expectations, looking at training or redeployment, so additional training, additional supervision, looking at mentors perhaps or buddies at work or somebody to help somebody at work or someone to check in with, or moving to a more suitable role where one exists. You're not expected to create a role, but if there are roles available that are suitable, someone could do with a bit of training, you are expected to consider them. So where SMEs come unstuck, never asking why. So jumping straight into a process without asking why performance has dropped. Using performance improvement plans as weapons. So they're used to build a dismissal file rather than genuinely trying to help someone to improve first. Acting on assumptions, so dismissing on sickness without trying to get up-to-date medical evidence and information. And where we see perhaps a pattern of someone's health improving or attendance is improving, trying to get to dismissal, so almost racing the employee whilst they're getting better to go, oh, you've hit a trigger, that's it, we've got grounds for dismissal, which is invariably going to be seen as unreasonable. So having those rigid absence triggers and having your blinkers on and not having any room for investigation or giving somebody time to get better, and that we've got no paper trail and nothing in writing until we get to that exit meeting and then trying to reconstruct it. If you're using our system, that's not going to be an issue because we've got all that performance stuff in there. We've got the ability for meeting notes and things like that and everything to be stored on that full audit trail against an employee. So if you don't have a system, make sure that at the very least you are taking notes when you are in meetings and that you're keeping them somewhere safe. And don't forget, when we're talking about health, that's a special category of personal data under data protection. We need to be keeping that stuff under lock and key. Consequences. Unfair dismissal, as we've talked about, the new consequences in January, that we've only got 6 months to get this stuff right. Disability discrimination from day one. Constructive dismissal, if someone feels like they're being taken through a rigged process, they may resign in response to that and then claim constructive dismissal. And then we could be facing the ACAS uplift as well if we get that process wrong. So quick poll on the screen, true or false, if an employee is missing targets, the performance management process is always the correct route. True, false, or I'm not sure. So nice quick one down there for you. And my final sort of golden nugget, and really I should have put this slide further towards the beginning, but I think it's quite a nice point to sort of be reaching the wrap-up point with, is always ask before we dive into a formal process, before we start looking at what we need the employee to do. Are we the problem? Is it that we haven't trained somebody properly? We're not supporting development? Have we got unsupportive managers? Is there bullying in the workplace? Has a role evolved and we've just not realized how much additional stuff and more complex stuff somebody's taken on without any supportive training? Has there been a really poor assimilation of duties, and is somebody frankly overworked because they've got new responsibilities or they've been integrated into a new team and they haven't been provided with resources, training, and less critical stuff hasn't been removed? So we've been piling on as we've been developing our business and actually not stripping away things that are no longer relevant to that employee when we've been giving them additional stuff to do. Are we the problem? We look at this first before we dive into anything then with the employee, because then we can put this right. If that still then doesn't secure improvement, we can then go into everything we've talked about in this session. And this is going to look really, really, really good if we go to tribunal. Not that we need to look good, but we're showing that we're not just blaming an employee without first having that bit of retrospective behavior where we're going, right, are we the problem? Is this something that we have done, before we automatically start blaming an employee and putting people under pressure? Writing everything down. So as I've already said, standards and support, make sure it's really clear what our standards are, what support we can give people and what we've given them, making sure that we're getting medical evidence on file, that we're considering adjustments and writing down and having our thought processes and the reasons why we have or haven't implemented something, and making sure that all outcomes are done in writing as well. So things to take away from this session: diagnose before you start managing. So is it can't, is it won't, is someone unwell? So the question decides everything that follows: the process, the evidence, and your legal exposure. Different problems, so different areas of law. So is there a skills gap? Is there a health issue? If it's a disability risk, remember day one, uncapped risk that we're facing here, and ask why something is an issue. So what is going on before we start to escalate? Make sure we understand why we are facing issues before we get knee deep into a process that we then have to undo later on. And don't forget, things are changing in January, which means that we're then only going to have 6 months to deal with employees who are not disabled. So you don't have to do this alone. We have our expert advice teams where a situation is live and you're unsure. We are available to support your team. Everybody who works with us loves my advice team. The people that we work with are absolutely fantastic. And the rate of tribunals or even threatened tribunals within our client base is so ridiculously low. It's something that we're really, really proud of because of that proactive support and how we work with people in terms of how we're resolving problems. We're also insurance backed. So if something goes wrong, then you are protected in terms of your legal costs, any payouts for settlements and compensation that tribunal might award. We've also got HR software. We've got e-learning, not only for employees, but also for managers. And we've also got Harry, our AI HR support agent. So if you don't have something in place, you can have all of this just for one subscription, and you get access to that then for, like I said, one monthly payment. So if this is interest to you, if you've been on these sessions, we've got a bit of a promotion because it's the summer. You can get a 25% discount on that 1 month subscription if you book in with a meeting today and end up signing to come on board with us. If you just want to come on, you want to be a bit nosy, see what we've got and what it all looks like, that's absolutely fine. We're always happy to talk to anybody. If you have any questions from this session, if there's anything that you didn't want to put in the chat and think you just want to actually pick my brains or chat to somebody on the team, that's absolutely fine. Just reach out to us and we can arrange for that session. The next masterclass series, I'm actually really excited about this one because I get to do a bit of law. What we're going to do, because we've done lots of theory, we've done lots of best practice, this is what we should do, this is what could lend you in tribunal, is we are going to take some key recent tribunal cases where employers have gone down badly and compensation has been awarded, and we're going to take them to pieces and work out where it went wrong, what the employer could have done that would have turned a situation around, and how they could have avoided the liability they got in tribunal. So we're going to do a deep dive into some really key cases for things that employers get wrong where they shouldn't be getting them wrong. So hopefully we can take the stuff that we've learned in these sessions and go and apply to some really practical scenarios that you can take away with some really, really great learning. So thank you so much for those of you who've been on every masterclass episode. I know we've got people who have come to every session without fail, so we really, really appreciate your support, which is why we've got this fantastic offer on for those of you who are going to be considering joining us and becoming part of our Heroes family. I hope you all enjoy the summer. We are talking about maybe taking a little bit of a break just to allow people with school holidays and availability and things like that. But we will be putting out dates for the next series as soon as we possibly can. So keep an eye out on LinkedIn. Follow us on LinkedIn if you don't do so already. But that's it. Only 7 minutes over today. I think this might be a record, though I did say I think we might put these in for 45 minutes because I clearly can't shut up once I get to that half an hour point. So yeah, enjoy your summer, everybody. If you're going anywhere near the water, please stay safe. Float to live. Go check out all the RNLI stuff. I can't leave a session in the summer without saying something like that. So please stay safe if you're anywhere near the water during the summer holidays. And I look forward to seeing you all on the next session. Thank you so much.